Chapter 6. The Source-Based Argument for the Judicial Obligation to Develop the Law. Part Roman 2, United States. A. The origins of common law review in the state courts. Americans today think of judicial review as the process by which judges review legislation to ensure compliance with the U.S. Constitution and, on occasion, to invalidate laws determined to violate the Constitution. The locus classicus for this authority is Chief Justice John Marshall's decision in Marbury. But as one scholar writes, well before Marbury v. Madison, there were instances of state court judges announcing the power of courts to annul unconstitutional legislation. Many of these state court decisions do not base judicial review on any canonical text. Instead, they use common law principles as the basis for the authority of judges to review legislation. In this respect, these state court cases are the direct descendants of Coke's decision in Bonham. In fact, Bonham is cited in some of these cases as legal authority for the result reached. For a thorough understanding of the development of judicial review in the United States, these state court cases are indispensable. To broaden current understandings of judicial review so that they accurately reflect the historical development of the doctrine, I must distinguish the current conception of judicial review from the alternative version that coexisted with it in 18th and 19th century America. To refer to the version of judicial review established by Marbury, I will use the term constitutional review. This term is intended to refer only to review of legislative action to ensure compliance with the dictates of the U.S. Constitution or the Constitution of any other legal system. To refer to the review of legislative action to ensure compliance with the principles of the common law, I will use the term common law review. As with constitutional review, I choose the term common law review to emphasize the body of legal principles against which legislative action is evaluated. I will continue to use the term judicial review to refer generically to judicial authority to review legislative action, without reference to the underlying body of law invoked in the evaluative process. As a corollary to this argument, I will explain that prominent colonial lawyers and judges recognized a doctrinal and theoretical distinction between common law and natural law as bodies of principle and bases for judicial decision. The influence of common law, rather than natural law, as a foundation for extra-constitutional judicial review provides a basis in Anglo-American legal sources for the exercise of review as a legal rather than extra-legal power of the common law judiciary. In an effort to clarify this discussion, I should define the terms natural law and common law as used here. Natural law is the legal theory that certain rights or values are inherent in or universally cognizable by virtue of human reason or human nature. Natural law theory is characterized also by a metaethical commitment to moral realism. In this way, whether something falls within the domain of the concept law is, for a natural lawyer, at least partially or nominally determined by reference to an extra-legal standard or norm. Common law is the legal tradition that certain rights or values are legally cognizable by virtue of judicial recognition of articulation. By legally cognizable, I mean capable of assertion by individuals through participation or representation in the legal process. Whether something falls within the domain of the concept law is, for a common lawyer, determined by legal standards and norms, the particular methods and sources of that legal tradition. Unlike natural law, the common law itself has no necessary metaethical or extralegal preconceptions. This conceptual distinction of common law from other, unwritten, or fundamental law was well known to certain early American lawyers and judges. I do not mean to suggest that all American judges always carefully observed the distinction, but some did, and it is worth seeing the coherent expression of this intellectual orientation in these early American cases. The mention of extra-constitutional judicial review and legal sources leads to another point. There is some question about what, precisely, the Constitution contains as a legal source. Is the Constitution the text alone, the text supplemented or supplanted by judicial interpretations of it, or the text as constructed by considerations of historical, social, and institutional context and moral justification? My claim is only the, I hope, uncontroversial assertion that the language of the Constitution maintains a unique and inescapable role in formulating constitutional doctrine. The constitutional text, however expansively or restrictively construed, is a source of law distinct from other sources of unwritten law, even if certain unwritten legal sources may possess a constitutional dimension. More specifically, as a matter of historical detail, legal theory, and constitutional law, the fact that the U.S. Constitution and various state constitutions were written was, and is thought to differentiate constitutional documents from the common law. Evidence of this differentiation may be found in the cases I will discuss in this chapter, because judges repeatedly referred to the common law and constitutional charters as independent, yet related sources of fundamental law. In this chapter, I will focus on carefully chosen phrases from certain judicial opinions, as support for my argument that the judges I discuss based their reasoning and decision-making on the common law. It might initially seem that this emphasis on particular phraseology is somewhat facile and haphazard, particularly in reference to cases decided 2 centuries ago. But as Forrest MacDonald explains, the chosen terms and phrases of the time in which these decisions were written are especially important to a historically accurate understanding of these judicial writings, because these repeated and related terms and phrases were often then, and now should be associated with particular ideologies or bodies of thought. Following MacDonald, then, I intend to show that the phrases I highlight were, and should be associated with an intellectual orientation that favored the common law as the basis for legal reasoning and judicial decision-making. I have 3 principal goals for this chapter. First, I hope to sharpen and clarify the doctrinal analysis of some early American case law about which scholars continue to disagree. I offer a historically grounded and theoretically integrated account of certain important decisions that helped to shape institutional relationships in the United States for the centuries to come. Second, I provide an account of judicial review that might help theorists better evaluate the genuine legal and historical meaning of American constitutionalism, in terms of the nature of the written U.S. Constitution and its implications for legislative authority, judicial autonomy, and individual rights. Third, I trace the distinctive contours of different sources of unwritten fundamental law. In particular, I draw attention, at certain points, to distinctions between common law and natural law as bodies of legal principle to which lawyers and judges appealed for support when arguing and deciding cases. Some scholars today believe that American lawyers in the 18th and 19th centuries drew no distinctions among these various sources of unwritten law. Others who accept that some Americans drew these distinctions read the cases I discuss here as providing the exercises of judicial review during this period with an underpinning based in natural law. Indeed, this natural law reading of these early cases is so widely accepted that people rarely pause to consider the matter. Both views are mistaken. Instead, I argue that the common law was the principal source of fundamental law on which several influential early American jurists relied as legal authority for judicial review. Appreciating this distinction and its implications is essential for a proper understanding of this case law, the authentic conceptual origins of judicial review and constitutionalism, and methods of legal reasoning and judicial decision-making. There is a long-standing and ongoing debate among American scholars of constitutional law, theory, and history about the authentic legal, theoretical, and historical basis for judicial review in the United States. The purpose of this chapter is to demonstrate that there is a legal, theoretical, and historical basis that does not depend on the written Constitution or on natural law, and that still provides a unique but limited authority for common law courts to preserve the rule of law in the United States. In other words, a complete understanding of the origins of judicial review and American constitutionalism requires an examination of more than constitutional review alone, because there may be another basis for judicial authority to review legislative action and to ensure conformity with legal principle. My argument diverges, then, from those made by such scholars as Will Wallachow, William Treanor, Sylvia Snowes, and Susanna Sherry. Wallachow seeks to apply common law processes of reasoning and adjudication to the constitutional morality intrinsic in charter documents. In contrast, I argue that the conceptual and historical legitimacy of judicial review in the common law tradition is exogenous to the existence or nature of a written constitution, in part because constitutions themselves reflect and instantiate, but do not supersede pre-existing common law principles. Triner argues very persuasively that there is important historical evidence to support an expansive, anti-literalist, to use his term, conception of judicial review during the founding period of the United States. Triner's interest lies in examining attitudes toward constitutional review during the late 18th century. Triner's arguments are therefore tangential, or perhaps parallel to my own. I am interested in studying early doctrinal support for judicial review during the period following the Revolution. But unlike Triner, I focus on the doctrinal foundations for this authority aside from, but sometimes alongside, constitutional review. In this respect, my focus is more closely aligned with the work of Snowis and Sherry. They too are interested in examining the doctrinal support for extra-constitutional judicial review during the colonial and post-revolutionary period. But they cite natural law as the extra-constitutional basis for judicial review at this time. As I describe in detail later in this chapter, common law, not natural law, was the most authentic basis for extra-constitutional judicial review during the late 18th and early 19th century in the United States. I should add two further clarifications. First, in the previous paragraphs, I refer to judicial review of legislative action. While this is my principal interest at this point, constitutional review is understood in the United States to extend to judicial review of actions of the executive, as well as the legislative branch of government, and I intend my discussion of common law review to extend similarly. Second, I also intend my discussion of common law review to encompass judicial review of prior judicial decisions. 1. Paxton's case, unreported decisions, and careful citations. The earliest prominent argument in favor of common law review by an American lawyer occurred in Paxton's case of the writ of assistance in 1761. James Otis resigned as Advocate General of Admiralty so that he could challenge the writs. Otis argued for a power of judicial review grounded specifically on the common law, complete with a citation to Coke's decision in Bonham. As early as 24 February 1761, Otis attacked the writs of assistance as being against the fundamental principles of law. And if an act of Parliament should be made in the very words of this petition, it would be void. The executive courts must pass such acts into disuse. Here was an explicit espousal of the doctrine of judicial review, and Otis based it on Coke, for he added, 8 Rep. 118 from Viner. Reason of the common law to control an act of Parliament. Otis's reliance on Bonham and Paxton would have an important and discernible influence on the development of judicial review by state courts in the period following the Revolution. The next 3 decades of American legal history saw the increasing influence of Bonham on state courts that based their power of judicial review on the common law. In the 30 years following Otis's argument in Paxton, state courts would assert, in several cases, a common law authority to invalidate statutory enactments. In reviewing these state court decisions, I restrict myself to cases in which state courts refer explicitly to the common law as the legal standard for reviewing legislative action, to draw particular attention to the invocation of the common law as a basis for judicial review independent from either natural law or a written constitution. Gordon Wood recognized the influence of common law constitutionalism on post-revolutionary conceptions of judicial review and of the legal restraints on legislative will. Unfortunately, however, the case Wood cites most prominently as the clearest expression of this Cokean conception is Rutgers v. Waddington. In addition to Rutgers, Wood mentions Trevitt v. Weeden and Bayard v. Singleton as developing the account of judicial review authority advocated by Otis and others. The problem with these citations is that none of these cases rests exclusively on a common law foundation. As Wood himself acknowledges, Rutgers rests, at least in part, on a possible violation of the New York State Constitution. To be sure, the court also seems to consider the conflict between the state legislation and the common law. but it is never clear precisely which body of legal principle the court deems controlling. In addition, and perhaps most important, the court explicitly disclaims any authority to reject the clearly expressed will of the legislature, as Wood also acknowledges. Trevitt primarily involved appeals to natural law along with common right and reason, while Bayard stands solely on a determination of unconstitutionality. Wood's reliance on these cases reinforces the importance of distinguishing carefully among the cases cited as support for different modes of early American legal thought and doctrine. These details of the opinions Wood cites leave me in the position of agreeing with his conclusion, but suggesting that the doctrinal support for that conclusion can be better found in the cases I examine here, rather than in the cases Wood selected. 2. Ham v. Imclaws. Ham v. Imclaws was the first reported case in which a state court ruled that legislation contrary to common law principles was void. Refusing to enforce the forfeiture statute at issue and incorporating arguments of counsel, the South Carolina court, consisting of Judges Grimke, Waddies, and Drayton, wrote, "It was therefore the duty of the court in such case to square its decision with the rules of common right and justice. For there were certain fixed and established rules, founded on the reason and fitness of things, which were paramount to all statutes. And if laws are made against those principles, they are null and void. For instance, statutes made against common right and reason are void." 8 Co. Rep. 118. It is clear that statutes passed against the plain and obvious principles of common right and common reason are absolutely null and void, as far as they are calculated to operate against those principles. Even without the overt citation to Bonham, the influence of Coke's decision is manifest in Ham. The South Carolina court's verbatim incorporation of the language from Bonham confirms the importance of Coke's decision to the court's ruling. 3. Bowman v. Middleton. 3 years later, in 1792, Bowman v. Middleton was decided by Judges Grimke and Bay of the South Carolina Court. Bowman involved a 1712 statute that transferred property ownership from one party to another. The plaintiffs inherited the land from the beneficiary of the 1712 enactment. Middleton had agreed to purchase the land from the plaintiffs. Middleton later refused to consummate the purchase, claiming that a portion of the property still belonged to the heirs of the original owner and not to the plaintiffs. The plaintiffs asserted complete ownership rights as derived from the 1712 Act. Despite the passage of 80 years since the putative transfer of ownership rights pursuant to the statute, the court ruled for Middleton and voided the 1712 statute as violative of common law principles. The plaintiffs could claim no title under the act in question, as it was against common right, as well as against Magna Charta, to take away the freehold of one man and vest it in another, and that too to the prejudice of third persons, without any compensation, or even a trial by the jury of the country, to determine the right in question. That the act was, therefore, ipso facto void. That no length of time could give it validity, being originally founded on erroneous principles. As with Ham, the court in Bowman tracks Coke's own language. Coke used the phrase common right and reason in Bonham. The Bowman court used the truncated term common right. Coke himself sometimes used the abbreviated term as a reference to the common law. The common law of England sometimes is called right, sometimes common right, and sometimes communis justitia. In the Grand Charter, the common law is called right, and all the commissions and charters for execution of justice are facturi quod ad justitiam pertinet secundum legem et consuetudinem Angli. So as in truth justice is the daughter of the law, for the law bringeth her forth. And in this sense being largely taken, as well the statutes and customs of the realm, as that which is properly called the common law, is included within common right. Bowman involved a statute enacted by the South Carolina colonial legislature. For this reason, and to avoid any possible retroactivity concern, the court's decision can be read as applying common law principles in effect when the statute was enacted. So, standing alone, Bowman does not settle the question of whether the state constitution and common law principles were viewed as distinct sources of fundamental law against which the 1712 statute was evaluated. The case would provide more certain guidance on this question if the statute at issue had been enacted after ratification of the state constitution. 4. Lindsay v. Commissioners. The South Carolina court reiterated the importance of the common law as a basis for evaluation of legislation in Lindsay v. Commissioners, which involved a takings issue. Specifically, the court was asked to determine whether property owners whose unimproved land was appropriated by the state for public use in constructing a street were entitled to compensation. After unanimously acknowledging the authority of the state to acquire the property, the court divided 2-2 on the state's obligation to provide compensation. Two aspects of this case are especially noteworthy for my argument. First, even though the judges disagreed about the proper disposition of the case, they all relied on common law principles as the legal basis for their reasoning and resolution. For example, Judge Thomas Waddies concluded, along with Judge E. Dennis Burke, that the legislation should be overridden and that compensation should be provided to the owners by the state. Judge Waddies clarified the legal basis for his conclusion as follows. Judge Waddies admitted the right of the state to take the property of an individual. But in exercising this power, it was essential to its validity that a full compensation should be provided at the time for every injury that the individual might suffer. The common law of England, which has also recognized this power, does it always with the same restriction. The rights of our citizens are not less valuable than those of the people of England. We have besides a constitution, which limits and controls the power of the legislature, the 9th article of which declares that no freeman shall be divested of his property, but by the judgment of his peers or the law of the land. On a former occasion, he said, he had gone into a long investigation of the technical import of the words lex terrae, and therefore should only state here that they meant the common law. He said he understood, therefore, the Constitution to mean that no freeman shall be deprived of his property, but by such means as are authorized by the ancient common law of the land. In what way, then, does the common law authorize the power of taking private property for public uses? By providing, says Mr. Blackstone, a full indemnification for it. This is the condition on which the valid exercise of this power depends. Judges John Grimke and Elihu Bay, who disagreed with Judge Waddies about the compensation question, nevertheless agreed with him that the common law was the legal source against which the subject legislation should be evaluated, as well as the legal limitation on the state's legislative power. As they put it, they considered the act in question as authorized by the fundamental principles of society. The legislature of South Carolina had exercised this power and authority to make and maintain public thoroughfares, from the first establishment of civil government in it to the present day. They therefore considered it as much a part of the common law of South Carolina as any other part of that great and valuable system. Second, a more subtle point of agreement between Judges Grimke and Bay and Judge Waddies concerned the relationship between the common law and the South Carolina Constitution. On this point, Judges Grimke and Bay wrote that it was neither against Magna Charta nor the state constitution, but part of the lex terrae, which both meant to defend and protect. The so much celebrated Magna Charta of Great Britain was therefore only declaratory of the well-known and established laws of the kingdom. So in like manner, the 2d section of the 9th article of our state constitution confirms all the before-mentioned principles. It was not declaratory of any new law, but confirmed all the ancient rights and principles which had been in use in the state. With their explicit statement that the South Carolina Constitution was not declaratory of any new law, Judges Grimke and Bay indicated their adherence to the view of many early American lawyers and judges that written constitutions reaffirmed the rights and principles of the common law. Moreover, this common law foundation of written constitutions informed the judges' interpretations of these constitutions, as is evident in the previously quoted extract from Judge Waddies' opinion. Lindsay demonstrates that these South Carolina judges viewed written constitutions as derivative of the common law, and that, even though they might mention both as legal sources against which legislative acts could be measured, this differentiation was not considered as ordinal or hierarchical. Both the common law and a written constitution might be used concurrently to evaluate legislation. But these judges did not consider a constitution to be higher or more fundamental than the common law. Judges Grimke and Bay, who had decided Bowman, agreed with Judges Waddies and Burke that the South Carolina Constitution was declaratory of pre-existing common law principles. This does not mean that the state constitution and the common law were necessarily coextensive with or entirely duplicative of one another, although they were interpreted in that way in this case. Moreover, my analysis of Ham, Bowman, and Lindsay suggests that judges on the South Carolina court, like Judge Carrington of the Virginia court in Jones, which I discuss next, apparently viewed the common law and constitutions as distinct mutually reinforcing bodies of fundamental law and as conceptually distinct bases for judicial review. 5. Jones v. the Commonwealth. Another example of a state court discussing common law review and constitutional review side by side occurs in Jones v. the Commonwealth. Jones involved the attempt to impose joint fines on several defendants who had been convicted of assault. In negating the fines, Judge Carrington noted their inconsistency with a common law principle that one person ought not to suffer for the fault of another. Judge Carrington then concluded, "Therefore, whether I consider the case upon the doctrines of the common law or the spirit of the Bill of Rights and the Act of Assembly, I am equally clear in my opinion that the district court should have required the jury to discriminate, and having failed to do so, that their judgment is erroneous and must be reversed." In Jones, which was decided after the ratification of the Federal Bill of Rights and before Marbury, we find the Virginia Supreme Court of Appeals articulating parallel doctrines of common law review and constitutional review. 6. Holmes v. Walton and the absence of hierarchy in legal sources. Some scholars who recognize the early legal and conceptual distinctions between common law and written constitutions assumed that these sources of law were ranked hierarchically in the minds of American lawyers and judges. These scholars believe that common law principles existed on a plane below statutory law and constitutions. This is a natural assumption for contemporary readers of dated legal materials to make, but it inaccurately renders the legal thought of the period. For example, Wayne Moore points out that in perhaps the first example of judicial review in American legal history, a state court articulated parallel doctrines of common law review and constitutional review. In Holmes v. Walton, the New Jersey Supreme Court apparently invalidated state legislation providing for trials in certain cases before 6-person juries rather than 12-person juries. The New Jersey court stated that the 6-person jury provision in the statute was contrary to the law, the Constitution of New Jersey, and the Constitution, practices, and laws of the land. As Moore indicates, the court's reference to the law seems to be a reference to common law and statute law, as distinct from the court's separate reference to New Jersey's written constitution. Moore goes on to claim that, as he sees it, the Constitution of New Jersey established a tripartite hierarchy, in which common law and statutory law, then existing, were at the bottom. Statutory law enacted subsequent to the New Jersey Constitution's ratification was in the middle, and the state constitution was at the top. The difficulty in Holmes was that the New Jersey Constitution did not stipulate a specific number of jurors, so the judges could not rely on the common law to invalidate a trial by 6 jurors, but had to rely on the constitutional text or other unwritten norms of higher authority than ordinary legislation. There are 2 problems with Moore's analysis. First, early American lawyers and judges did not draw sharp or categorical distinctions between common law and constitutional law. As I mentioned in my discussion of Lindsay, the common law provided the substantive and procedural basis for American federal and state constitutions. Lawyers and judges of the time recognized the political importance of committing to writing their fundamental charters of government, but they did not believe that these charters were, by virtue of being written, necessarily exhaustive or transformative expressions of legal rights. Second, where a fundamental common law right was concerned, such as trial by jury in Holmes, the common law could continue to function as, in Moore's words, an unwritten norm of higher authority than ordinary legislation. In their reception and integration of English common law into American jurisdictions, American lawyers retained Coke's view that Magna Carta together with traditional common law made up a body of fundamental law, and that fundamental common law principles could guard against the slightest inroads on traditional constitutional guarantees, such as the threat to trial by jury. In other words, not all common law rights were created equal. There is no doubt that a legislature could alter certain existing common law rights, e.g., in the law of contract. But it is another thing altogether to say that the legislature could statutorily alter or abrogate more cherished and fundamental common law rights, such as the right to a jury trial or the ownership of private property. Put differently, the recognition of the judiciary as a co-equal branch of government in America in reaction to the English tradition of parliamentary sovereignty meant that the courts were charged with the constitutional responsibility to preserve fundamental rights, e.g., the right to a jury trial, and to ensure that the legislature acted in accordance with fundamental law, common law, or constitutional text. Although the constitutional doctrine of sovereignty would occupy many British legal minds during this period, the Cokean conception of common law constitutionalism was fully embraced by their American counterparts in the latter half of the 18th century. Scholars who assume that the common law was ranked below statutory or constitutional law in the minds of early American lawyers and judges miss the intrinsic differences among common law rights. Some common law rights, such as the right to trial by jury, were frequently mentioned explicitly in constitutional texts. But this was primarily an effort to reaffirm a political and legal commitment to this right, when called on to determine the qualities and contours of the right. As the New Jersey Supreme Court was in Holmes, it is unsurprising that the court would mention the common law and the state constitution as separate, independent, equally meaningful foundations for that right. The common law did not cease to exist as a basis for grounding the existence of the right to a jury trial, or as a basis for determining the specific procedural requirements of that right, simply because the importance of that right was accentuated by the drafters of the New Jersey Constitution. As George Anastaplo puts it, fundamental common law rights were always considered by early Americans to be constitutionally available to them, independent of what any document might say from time to time. The 12-person jury was a cherished, ancient common law right. When confronted with legislation that conflicted with this right, the New Jersey court was not deterred by the state constitution's silence or the legislation's recent enactment. The Holmes court cited common law and constitutional law as parallel bases for judicial review precisely because both sources of law remained operative in locating and defining fundamental rights. Today, Americans assume that judicial review is synonymous with constitutional review. But this misconceives the development of judicial review in early American legal history. Judicial review and constitutional review are not coextensive. As Ham, Bowman, Lindsay, and Jones demonstrate, common law review existed alongside constitutional review during the formative period of American constitutional thought. Early American state courts instituted a doctrine of judicial review founded not solely on a constitutional text, but also on the common law. As I will show in the next section, during this same period, the U.S. Supreme Court and Chief Justice John Marshall himself continued to refer to common law principles as a basis for evaluating legislative action independent of and parallel to the text of the Constitution, even after Marshall established constitutional review through his famous decision in Marbury. B. The origins of common law review in the Supreme Court. Calder v. Bull. Before and after Marbury, the U.S. Supreme Court invalidated legislative action on the basis of common law principles along with or instead of constitutional provisions. In this way, the Supreme Court endorsed the practice of common law review in much the same way, and during the same period, that the state courts had. The first example of common law review in the Supreme Court is Calder v. Bull. Calder involved a will dispute in Connecticut. The Connecticut probate court that heard the case invalidated the will. In response to the court's decision, the state legislature abrogated the court's ruling and ordered a new trial. At the second hearing, the probate court upheld the will. The heirs, Caleb Bowl and his wife, who would have recovered by intestacy had the will remained invalid, appealed the probate court's second ruling, claiming that the legislature's action violated the ex post facto provision in Article I, Section 10 of the U.S. Constitution. The Supreme Court refused to override the Connecticut legislature's act. In his seriatim opinion, Justice Samuel Chase expressed his belief that the prohibition against ex post facto laws obtained only in the criminal context. As a result, he ruled that the civil nature of Calder rendered the ex post facto clause inapplicable. Though Calder's holding is somewhat forgettable, Calder contains two justices' seminal statements of competing views concerning the characteristics of a written constitution and its implications for the scope of judicial review and the balance of governmental powers. Simply put, one view held by Justice Chase maintains that the rights and principles found in the Constitution's text are not exhaustive of the rights and principles to which judges may appeal when reviewing the legality of governmental actions. The second view, taken by Justice James Iredell, is that the rights and principles to which judges may refer when reviewing exercises of public power are delimited by the text of the Constitution. In his famous enunciation of the first view, Chase wrote, "There are acts which the federal or state legislature cannot do without exceeding their authority. There are certain vital principles in our free republican governments which will determine and overrule an apparent and flagrant abuse of legislative power, as to authorize manifest injustice by positive law. The genius, the nature, and the spirit of our state governments amount to a prohibition of such acts of legislation, and the general principles of law and reason forbid them. To maintain that our federal or state legislature possesses such powers, if they would not be expressly restrained, would, in my opinion, be a political heresy, altogether inadmissible in our free republican governments. But if I ever exercise the jurisdiction, I will not decide any law to be void, but in a very clear case. If then a government composed of legislative, executive, and judicial departments were established by a constitution which imposed no limits on the legislative power, the consequence would inevitably be that whatever the legislative power chose to enact would be lawfully enacted, and the judicial power could never interpose to pronounce it void. It is true that some speculative jurists have held that a legislative act against natural justice must in itself be void. But I cannot think that, under such a government, any court of justice would possess a power to declare it so. In order, therefore, to guard against so great an evil, it has been the policy of all the American states, which have, individually, framed their state constitutions since the Revolution, and of the people of the United States, when they framed the federal Constitution, to define with precision the objects of the legislative power, and to restrain its exercise within marked and settled boundaries. If any act of Congress, or of the legislature of a state, violates those constitutional provisions, it is unquestionably void. Though I admit that the authority to declare it void is of a delicate and awful nature, the court will never resort to that authority, but in a clear and urgent case. If, on the other hand, the legislature of the Union, or the legislature of any member of the Union, shall pass a law within the general scope of their constitutional power, the court cannot pronounce it to be void, merely because it is, in their judgment, contrary to the principles of natural justice. Chase and Iredell agreed on many things. Least important, they agreed that the prohibition against ex post facto laws extended only to criminal cases. They also agreed that the U.S. Constitution and its system of government were intended to avoid the perceived imbalances of the English style of government, especially those occasioned by parliamentary sovereignty. Furthermore, they agreed that judges should assert the authority to review legislation only in very clear cases. Finally, they agreed that the Constitution furnished a body of legal principle that judges could invoke in reviewing legislative action. But of course they disagreed vehemently about whether the Constitution furnished the exclusive body of principle for this purpose. And accordingly, they disagreed about the instances in which judges could appropriately exercise this authority. Obviously, I fall on Chase's side of the fence. My specific purpose here, though, is not to defend Chase's position against Iredell's concerns. My entire project is devoted to that effort. Instead, I want to explore the precise meaning of Chase's opinion. Chase's reference to the general principles of law and reason is a reference to the common law. Some writers claim that Chase's decision in Calder asserts a natural law basis for judicial review of legislation. This claim is curious, if not utterly baseless, given the common law's prominent role in Chase's opinion and the conspicuous absence of any reference to natural law, natural rights, or the law of nature anywhere in Chase's opinion, or in the opinion of any other justice who decided Calder. Moreover, as Leonard Levy explains, unenumerated positive rights, deriving from the social compact that creates government, were distinguished from natural rights in the minds of American lawyers and jurists of this period. Taking this distinction into account helps to illuminate Chase's well-known but not well understood statement in Calder that legislative acts, contrary to the great first principles of the social compact, cannot be considered a rightful exercise of legislative authority. These legislative acts were void, according to Chase, because they conflicted with the positive rights protected at common law as distinct from natural rights. Positive rights were derived by reference to legal sources, common law, constitutional, or statutory, while natural rights were claimed by virtue of human dignity. Chase's reference in Calder to legislative acts that conflicted with the social compact is best understood, not as an allusion to natural rights or natural law, but instead as a statement about judicial authority to review legislation that contradicted positive rights grounded in acknowledged sources of law. One scholar troubled by the tendency to read natural law into Chase's Calder opinion is Matthew Frank. In responding to the natural law reading of Chase's opinion, Frank argues that Chase was not invoking any judicial authority to refer to non-constitutional fundamental law when reviewing legislative enactments. Instead, Frank says, Chase's well-known statements turn out to be little more than an aside in political theory of limited government derived from the social contract with, practically speaking, no juridical significance. There are two problems with Frank's argument. First, as Frank himself notes, Chase explicitly refers in Calder to certain vital principles that will overrule a legislature when it authorizes manifest injustice by positive law. As Frank also concedes, the examples Chase uses to exemplify such injustices were forbidden by either the statute law or common law of England, precisely the sources from which Connecticut's charter derives its limits on legislative power. Frank then refers to one of the examples of injustice selected by Chase, the principle that no man should be judge in his own case, and concludes that this places Chase squarely in the tradition of Blackstone, which is probably where Chase derived the example. Of course, as I have tried to show, Chase's opinion and the example Frank cites place Chase squarely in the tradition of Coke and Bonham, which is more likely to be the source from which Chase derived the example. Due to the overwhelming inclination to assume that the issue in Calder is whether Chase's opinion is or is not derived from natural law reasoning and principles, Frank is a victim of asking the wrong question. He is right about the widespread misreading of Chase's opinion as based on natural law, but rather than looking to an alternative source of fundamental law, he attempts to construct a reading of Chase's opinion that resembles a political tract more than a judicial opinion. This results in the yeoman's effort by Frank to avoid or reconstruct the explicit language of Chase's opinion and leads directly to the second problem with Frank's conclusion. To his credit, Frank appreciates that his attempt to debunk the orthodox Calder myth necessitates an explanation of Iredell's pointed apparent retort to Chase in his opinion. Frank cites certain historical speculations, i.e., perhaps Iredell did not hear Chase's opinion, or perhaps Iredell's apparent response to Chase was instead directed toward arguments of counsel as potential support for doubting that Iredell's opinion was intended as a response to Chase. In addition, Frank says that Iredell was not a legal positivist who rejected the existence of natural law. Rather, Frank says Iredell does not deny either the existence or the moral force of natural law as a standard for the positive. But of course, this just begs the question. The issue in Calder is not whether natural law existed as a body of legal principle familiar to lawyers and judges trained in the 18th century. The question is whether this familiar body of extra-constitutional fundamental law or some other could be employed by judges to review legislative acts. For good reason, Calder is widely understood as a disagreement between Chase and Iredell about the nature of a written constitution and the basis of judicial authority. Frank's attempt to challenge this widespread understanding leads him to reinterpret Chase's opinion, downplay the apparent theoretical dispute between Chase and Iredell, and entirely recast the meaning and import of the decision. Finally, Frank says that the speculative jurists to whom Iredell refers in his opinion were not Chase and those who might agree with him about extra-constitutional judicial review, but rather the theorists studied by lawyers of the day: Blackstone, Pufendorf, Vattel. He suggests that Iredell actually should be read as subscribing to the views of the speculative jurists he mentions. Leaving aside the incongruity of this reading with the language and structure of Iredell's opinion, two aspects of Frank's list of jurists are noteworthy. First, Frank's list consists of 3 natural lawyers. By omitting Koch from this list, Frank fails to acknowledge a powerful influence on Anglo-American legal education and thought at this time. Second, as I will explain in the next section, Frank's attempted reading of Iredell in Calder does not cohere with Iredell's other judicial opinions, e.g. Cashapp, or with Iredell's broader intellectual focus on recognized, definitive legal sources, e.g. a written constitution. Other scholars suggest that any attempt to seek a coherent distinction between common law and natural law in early American legal thought is hopeless, because early American lawyers were hopelessly muddled about the matter. But I am more sanguine. For my purposes, the issue is not whether some early American lawyers and judges conflated common law and natural law. I only intend to argue that some early American lawyers and judges did not. Although there was confusion about the doctrines in America, as there had been in England, common law and natural law were recognized by certain early American lawyers to be distinct bodies of principle. Other early Supreme Court opinions and the arguments of counsel presented to the court in these cases offer support for this claim. 2. Cashapp v. Georgia. The first opinion to support the claim that common law and natural law were recognized as distinct by certain early American lawyers is Justice Iredell's opinion in Cashapp v. Georgia. The question raised in Cashapp was whether a private party resident of one state could bring suit against a sister state in federal court for violation of state law. The Cashapp majority held that a state could be sued in a federal forum, in an appropriate case, by a resident of another state. The principal bases for the majority decision were the plain language of Article Roman III of the U.S. Constitution, the practical necessity of enforcing the Constitution's provisions against the states, and the state's implicit consent to suit by virtue of each state's ratification of the Constitution. The Supreme Court's decision in Cashapp resulted in the enactment of the 11th Amendment, which precludes federal jurisdiction over claims by private parties against individual states. Iredell dissented in Cashapp. Perhaps realizing the futility of contesting the language of Article Roman III prior to the enactment of the 11th Amendment, Iredell instead focused on the Judiciary Act of 1789 in maintaining that a state was immune from private suit in federal court. In his analysis of the statutory language, Iredell took the phrase, "the principles and usages of law," in the Judiciary Act to mean the common law. Iredell's reading of the Judiciary Act is important for 3 reasons. First, Iredell's understanding of the general statutory language as a reference to the common law shows that early American lawyers differentiated common law from natural law, and that they viewed the common law as the body of doctrine relevant to judicial reasoning. When considering the possibility of disparities in the law of different states and the value of continuity in the law of the United States, Iredell grasped the need to recognize and establish a coherent body of legal principle applicable to all states in the Union. He found that body of principle in the common law. The only principles of law, then, that can be regarded are those common to all the states. I know of none such which can affect this case, but those that are derived from what is properly termed the common law, a law which I presume is the groundwork of the laws in every state in the Union, and which I consider, so far as it is applicable to the peculiar circumstances of the country, and where no special act of legislation controls it, to be in force in each state, as it existed in England. Later in his opinion, Iredell reaffirmed his exclusive reliance on the common law as the determinative legal source on which he based his opinion. We have no other rule to govern us but the principles of the pre-existent laws, which must remain in force till superseded by others. Then it is incumbent upon us to inquire whether previous to the adoption of the Constitution which period, or the period of passing the law, in respect to the object of this inquiry, is perfectly equal in action of the nature like this, before the court could have been maintained against one of the states in the Union upon the principles of the common law, which I have shewn to be alone applicable. Iredell continued to refer to the common law throughout the remainder of his opinion, and it was only after establishing the common law as the exclusive body of principle relevant to the decision in Cashapp that Iredell mentioned natural law in passing. Iredell's Cashapp opinion represents a compelling example of an early American jurist distinguishing the common law from natural law, and confirming the prominence of the former in judicial decision-making. Second, the reference to the principles and usages of law in the Judiciary Act discussed by Iredell and Cashapp is markedly similar to the phrase, the principles of law and reason, used by Justice Chase and Calder. Here again, we find the influence of the identification of common law principles with the principles of right reason. Despite their theoretical disagreement in Calder, Chase and Iredell would both have understood such a general phrase as the principles of law to refer to the common law as Iredell did in Cashapp. Chase and Iredell would both have understood Chase's phrase, the principles of law and reason, to refer to the reason and principles of the common law. Third, Iredell's Cashapp opinion takes on added significance given Iredell's consistent recognition of the importance of authoritative legal sources. As a result of his opinion in Calder, his argument in Bayard, and other written remarks, many scholars highlight Iredell's fondness for written statements of law, particularly the written U.S. Constitution. This is undoubtedly an accurate assessment of Iredell's intellectual perspective as a lawyer and a judge. But Cashapp suggests that Iredell also viewed the common law as a uniquely important legal source, even in cases of constitutional significance. The salient point seems to be that Iredell focused on definitive legal articulations of rights and constraints on legislative power. These expressions of law need not be limited, however, to a written constitution or for Federalists, such as Iredell by a Bill of Rights. Iredell believed in the importance of law as an external limitation on legislative power intrinsic to genuine constitutionalism, but the rule of law was not necessarily, ultimately, or exclusively confined to the text of the Constitution itself. The rule of law was preserved by judges applying accepted legal principles and processes to restrain the government and to ensure the liberties of the people. For Iredell and certain other early American jurists, the common law provided these authoritative legal principles and processes, while natural law did not. 3. McIlvaine v. Cox's Lessee. Another contemporaneous case that exemplifies early American reliance on common law rather than natural law as the authoritative source of judicial determination is McIlvaine v. Cox's Lessee. McIlvaine involved an inheritance claim founded on the property rights of an individual born in New Jersey who supported Britain during the Revolution. The most interesting aspect of the case, for my argument, is that counsel for both the plaintiff and the defendant relied on principles of common law rather than natural law as support for their arguments. For example, plaintiff's counsel noted that natural allegiance, i.e., the allegiance due from birth, is the only kind which by the rule of the common law cannot be shaken off. Defense counsel's argument was even more explicit in rejecting natural law in favor of the common law as uniquely relevant to legal argument and judicial decision. Whatever might be the principles of natural law, by the principles of common law, Daniel Cox had a right to inherit lands in New Jersey. Counsel raised natural law only to discard it in favor of the common law. Although the Supreme Court's opinion turned on its interpretation of New Jersey's state sovereignty and relevant legislation, it is noteworthy that the court expressly mentioned the principles of the common law, while making no reference to natural law anywhere in its opinion. As in Cashapp, the court and counsel in McIlvaine based their reasoning only on common law principles or statutory law. Common law ideas of sovereignty and sovereign immunity in colonial and post-revolutionary America were influenced by the growing mistrust of English ideas of absolute legislative supremacy. It comes as no surprise, then, that judges and lawyers working in this legal and political atmosphere should look to the common law as the legal basis for controlling threatened abuses of legislative power. American lawyers linked common law with right reason, distinguished common law from natural law, and relied on the common law rather than natural law in formulating and amplifying legal doctrines that touched on the most fundamental aspects of the nascent federal system of government and its balanced separation of powers, which eschewed English parliamentary sovereignty and embraced a judiciary with accepted powers of judicial review. 4. Fletcher v. Peck. Calder was decided 5 years before Marbury. But Marbury's establishment of constitutional review in America did not end the Supreme Court's reliance on the common law as an alternative basis for judicial review. In Fletcher v. Peck, decided 7 years after Marbury, Chief Justice Marshall continued to invoke common law principles as a basis for judicial review apart from review by exclusive recourse to constitutional provisions. Fletcher involved the conveyance of land in Georgia from John Peck to Robert Fletcher by deed. Unfortunately, however, some of the Georgia state legislators who originally voted in favor of the grant by which Peck's predecessor, James Gunn, acquired title to the property were bribed. The Georgia legislature subsequently annulled the earlier, tainted act and rescinded the land grant. The problem presented in Fletcher centered on the ability of the Georgia legislature to annul the original land grant to Gunn, thereby stripping Peck of his ownership interest and Fletcher of his purchase. The Supreme Court refused to acknowledge the subsequent act of the Georgia legislature, relying on 2 grounds for its decision. First, Marshall referenced the common law rule that bona fide, innocent purchasers of land for valuable consideration acquire good legal title. Second, Marshall indicated that the act of the Georgia legislature, purporting to vitiate the original land grant, was tantamount to a law impairing the obligation of contracts in violation of Article I, Section 10 of the U.S. Constitution. Combining these 2 rationales for the court's ruling, Marshall wrote, "It is, then, the unanimous opinion of the court that, in this case, the estate having passed into the hands of a purchaser for a valuable consideration, without notice, the state of Georgia was restrained, either by general principles which are common to our free institutions, or by the particular provisions of the Constitution of the United States, from passing a law whereby the estate of the plaintiff in the premises so purchased could be constitutionally and legally impaired and rendered null and void." In this passage, Marshall indicates 2 parallel bases for the court's invalidation of the Georgia legislature's action. According to Marshall, the act of the Georgia legislature was subject to invalidation either for violating general principles or for violating the Constitution itself. Commentators have recognized Marshall's reliance on these dual grounds of constitutional and extra-constitutional review of legislative action in Fletcher. These commentators have also noted that the general principles referenced by Marshall and Fletcher are the same principles discussed by Chase in Calder. As with Chase in Calder, Marshall's reference to general principles in Fletcher is a reference to the principles of the common law. Accordingly, Calder and Fletcher stand for the proposition that the principles of the common law provide a legal basis for judicial review of legislative action independent of, and along with a written constitution. Moreover, as in the proper reading of Bonham, the power of common law review cannot be divorced from its attendant implications for the relationship among the branches of plural government. Marshall seemed to recognize this in Fletcher. It is the peculiar province of the legislature to prescribe general rules for the government of society. The application of those rules to individuals and society would seem to be the duty of other departments. How far the power of giving law may involve every other power, in cases where the Constitution is silent, never has been, and perhaps never can be, definitely stated. Marshall wisely and cautiously left the door open in Fletcher. He might well have believed that common law principles had to be maintained as an independently viable basis for judicial review, because he did not yet know what the political and legal fate of constitutional review would be. Of course, constitutional review would soon be accepted as a part of the constitutional structure of American government. And as constitutional review became widely accepted, common law review was gradually forgotten, until we have today reached a point where American lawyers and judges believe that the only available basis for judicial review is by reference to the Constitution. But as Calder and Fletcher demonstrate, this does not seem to be what Marshall or Chase foresaw. Additional support for this argument, and for the focus on the precise language of certain key passages in these judicial opinions, may also be found in Marbury itself. Marshall's chosen phrasing, "The Constitution controls any legislative act repugnant to it." An act of the legislature, repugnant to the Constitution, is void, seems to echo Coke's language in Bonham. In Marbury, Marshall concentrated his attention on the written Constitution, but his later decision in Fletcher makes it clear that he did not believe, even when he wrote Marbury, that the written Constitution was the exclusive legal basis on which courts could invalidate abuses of legislative power. In his opinions in Marbury and Fletcher, in his private writings, and in his less famous judicial opinions, Marshall indicated that the common law was anterior to and incorporated in the substantive guarantees of the Constitution, and that the common law continued to exist as an independent body of fundamental law binding on the government and the people after the Constitution's ratification. Throughout the founding period of the United States, American judges and lawyers viewed the common law as a legal constraint on governmental power, echoing and incorporating the common law's long-standing link in English constitutional thought to the rule of law and to common law constitutionalism, a link that had largely been forgotten in the England of that day, with its constitutional commitment to parliamentary sovereignty. The reliance by the Supreme Court and Council on the common law as the predominant method and source for legal argument and decision-making continued well after Fletcher. Other cases from the first quarter of the 19th century indicate the post-colonial American preference for common law, rather than natural law as a source of legal authority. The cases I cite and discuss here are, and can only be suggestive of American legal attitudes and practices at this time. To be sure, other cases could be found in which natural law seemed to play the principal role, and still more cases could be found in which courts or counsel might seem to refer to common law and natural law carelessly, if not synonymously. But my effort here is not to establish that all American lawyers during this period maintained a precise and pristine distinction between common law and natural law. I only aim to show that some lawyers and judges did appreciate this distinction, and that some of these lawyers and judges recognized the common law as forming the legal and theoretical basis for an alternate practice of judicial review that did not necessarily derive from the text of the Constitution. The development of common law review in the Supreme Court mirrored the state court experience. Common law review was first articulated, to some extent, in isolation. Here, Calder can be equated with Ham and Bowman, but quickly, as evidenced by the Virginia Supreme Court in Jones and Marshall's opinion in Fletcher, and less explicitly by the South Carolina Court in Lindsay and Iredell's opinion in Cashapp, American judges realized that common law review and constitutional review could stand alongside one another, providing complementary bases for judicial evaluation of legislative and executive action. See common law and natural law again. Although many of the cases cited and discussed in this chapter have received far less scholarly attention than they deserve, most have received some. Now that I have explained my reading of these cases and their conceptual connections, I should respond to the work of some scholars who also have studied these cases. I cannot here fully address all of the points raised by these writers, but some remarks seem especially pertinent. For the most part, I am concerned here to correct a common misreading of these cases as being grounded on natural law principles rather than on principles of common law. I do not argue that common law and natural law were or are entirely irreconcilable. On the contrary, certain common law principles were understood as reflective of natural law precepts. My case analysis is intended to demonstrate, however, that the more general relationships between common law and natural law did not necessarily filter down to their reception by courts as authoritative sources of legal doctrine. In deciding cases, certain American judges distinguished common law and natural law as sources of law. And this is where the distinction matters for my purposes as a theoretical and doctrinal foundation for the exercise of judicial review. Before turning to some specific remarks about the cases themselves, I should respond to a preliminary point. John Philip Reed is quite dismissive of the influence of natural law on the recognition of specific rights during the colonial and post-revolutionary period. In fact, he states that natural law was never the dominant source of law, and perhaps not even a significant one. It is fair and accurate to say, as Reed and MacDonald do, that natural law was disfavored by some lawyers and politicians of the time, because it was taken to be too amorphous and evanescent a foundation on which to ground law or rights. But it is also true, as Reed sometimes concedes, that natural law did serve as authority for legal claims and rights in judicial decisions, legislative acts, and legal pronouncements. It seems to me that the frequent references to natural law in judicial opinions and elsewhere cannot be dismissed entirely as mere rhetorical flourishes, given the doctrine of precedent and the character of legal sources in the common law tradition. It seems unavailing and unnecessary to deny that some early American lawyers treated natural law as a source of principles available to judges in the recognition of legal rights and the assessment of legislative enactments. This is the reason that I focus so carefully on the cases I have chosen and the language I have cited. The crucial point, I think, is to see that certain early American lawyers and judges carefully distinguished natural law from common law and referred to the latter as the basis for legal argument and judicial decision. The cases I discuss are indicative of an important and distinct perspective in American legal thought, a perspective according to which common law appeared as singularly authoritative. This is entirely sensible, considering that in the period on which I focus, American judges were beginning to assert an institutional authority and autonomy grounded in English legal tradition, but nevertheless unfamiliar to English constitutional structure and orthodoxy, at least as it was then, and is now commonly understood. To some important American lawyers and judges reared in the English legal tradition, the common law did not suffer from the specific conceptual and legal weaknesses that seemed to undermine natural law. While natural law was viewed by some common lawyers as too tenuous a legal basis for grounding concrete rights and governmental limitations, the common law represented a body of historically and legally established concepts and doctrines, e.g., due process, jury trials, liberty and property rights that defined the institutional position of the judiciary and its obligation to preserve individual rights. Whatever its moral force might be, natural law was not a recognized legal source as common law was. Reconsidering the cases discussed in this chapter will, I hope, help to reorient the study of early American judicial review and clarify the distinctive evolution of public law in the United States. Two scholars who have considered some of the same cases I discuss, but who read them differently, are Sylvia Snowes and Susanna Sherry. My disagreements with Snowes about these cases are less stark and less comprehensive than my disagreements with Sherry. In her discussion of Lindsay, Snowes states that the case represents an amalgam of natural law and positive law. Snowes then goes on to stress that judges on both sides of the legal outcome based their reasoning on the common law, and she notes Judge Grimp's acknowledgement that the state constitution reaffirmed pre-existing legal rights and principles rather than creating new ones. She concludes by observing that the Lindsay Court evaluated the subject legislation in light of both the South Carolina Constitution and common law principles, suggesting that these served as independent bases of review for the court. Given the prominence of the common law in her analysis of Lindsay, Snowes's initial reference to natural and positive law might just be a seemingly minor linguistic slip. But as I argue in this chapter, this sort of imprecision may allow us to miss subtleties in the thought and language of certain 18th and 19th century American judges concerning the sources of judicial authority and the development of American constitutionalism. I agree with some of what Snowes says about Fletcher as well. She recognizes, for example, that Fletcher provides alternate grounds for judicial renunciation of legislation. Unfortunately, though, she believes Marshall treated natural law as the extra-constitutional foundation for the decision. As I have already explained, the language and reasoning of Marshall's opinion do not support a natural law reading of Fletcher. In contrast to Marshall's own opinion, however, Justice Johnson's concurrence in Fletcher does rest on natural law grounds, mainly due to his pointed effort to distinguish his reasoning from Marshall's, through his reference to a principle which will impose laws even on the deity. In fact, Johnson's decision to write a separate opinion based on natural law actually reinforces the common law reading of Marshall's opinion. Snowes accepts this to a degree. She considers Johnson's opinion strikingly different from Marshall's. But she and I see the difference differently. For Snowes, the difference turns on Johnson's vision of government limited by natural law and natural rights as compared with Marshall's reliance on the exposition of constitutional text to invalidate legislation. To me, the language of Fletcher indicates that Marshall understood the legal limitations on legislative power as inhering in more than the Constitution's text alone, in contrast with Johnson's reliance on natural law as the extra-constitutional restraint on government power. Marshall relied, at least in part, on the common law in support of the same end. The connection of the state court cases to the Supreme Court cases in the development of common law review raises another issue. I have already mentioned that some scholars interpret Justice Chase as invoking natural law, rather than common law, as the basis for extra-constitutional review in Calder. Sherry, for example, sees Fletcher and the state court cases I have discussed as based on natural law, rather than common law. According to Sherry, in Fletcher v. Peck, the written Constitution vied with unwritten principles of natural law for pride of place among the sources of fundamental law. Similarly, where the state court cases are concerned, Sherry claims, the judicial enforceability of natural law in South Carolina is best illustrated by two early cases. In Ham v. M. Claus and 3 years later, in Bowman v. Middleton, where the court went further and actually invalidated a statute on the basis of unwritten law. Sherry makes these assertions despite quoting the Ham court's references to common right and common reason, and the Bowman court's references to common right and Magna Charta, and despite the fact that not a single reference to natural law or the law of nature appears anywhere in Fletcher, Ham, or Bowman. It is difficult to know what to make of Sherry's apparently indiscriminate references to natural law, rather than common law, as the extra-constitutional fundamental law invoked by the courts in Fletcher, Ham, and Bowman. Sherry may provide the answer, though. Despite appearances, she is ostensibly cognizant of subtle differences among the different sources she categorizes as unwritten law. Sherry writes, the written Constitution was only one of several sources of fundamental law. Other sources, all unwritten, included the laws of God, the common law, the law of nature, and natural law. The law of nature and natural law were related but distinguishable in the period I am discussing. The former was grounded in observation and human sentiment, while the latter was founded upon abstract reason. For purposes of this article, the differences among the various unwritten sources of higher law are irrelevant. Therefore, I will use unwritten law, natural law, and law of nature interchangeably. I am troubled by several aspects of this statement, all of which I will not pursue at length here. Especially worrying for my present purposes is Sherry's indifferent gloss over the several sources of unwritten law. Sherry says that the differences among the laws of God, the common law, and natural law are irrelevant for the purposes of her article. But one of the purposes of her article is to analyze the historical and theoretical basis for extra-constitutional review of legislative action in late 18th century and early 19th century American law. The theoretically disparate foundations of common law and natural law, to say nothing of divine law, cannot be more relevant to this project. If the basis of extra-constitutional judicial review were natural law, this might raise genuine concerns about the legal source of the authority at issue, and about the desultory and unconstrained nature of the enterprise. If the basis of extra-constitutional judicial review is the common law, however, then judges remain bounded by the authoritative methods, concepts, and sources established and recognized within the Anglo-American legal tradition. These are, it seems to me, two drastically different things. Particularly for Sherry's and my purposes, the distinction between natural law and common law cannot be discounted. Others have noted some of these deficiencies in Sherry's analysis. Christopher Eisgruber, for one, identifies the problems with Sherry's treatment of Fletcher and highlights the common law, as opposed to natural law basis of Marshall's opinion. But the aspect of Sherry's work that is most problematic from my perspective is her citation of Bonham as support for her argument. Even worse than simply citing Bonham, Sherry goes on to claim the Kochian and continental notion of fundamental principles and the more Lockean idea of fundamental rights are two sides of the same coin. Both were grounded on unwritten natural law. Leaving aside the doctrinal and historical differences between Kochian and continental notions of fundamental principles, Koch's notion of fundamental principles and Locke's idea of fundamental rights are not both grounded on natural law, and it is misleading to suggest that they are two sides of the same coin. They are very different coins. They may, however, sometimes be found together in the same pocket. The problems with Sherry's position have both a theoretical and a practical dimension. At the theoretical level, to a legal positivist, and even to some natural lawyers, fundamental rights cannot be confidently claimed as legal rights until they are articulated at the level of common law or by some other authoritative means in a common law system. Sherry does not adequately differentiate the status of natural law and common law as sources of authoritative legal principle and doctrine that could be and were relied on by judges in some of the cases she discusses. At the practical level, natural law conceptions of fundamental rights generally maintain that these rights inhere immutably in human beings, irrespective of their recognition within a particular legal order. They do not depend for their existence on positive law, and they cannot be abrogated or altered by legislative or judicial action. Common law rights, even for Koch, were generally defeasible by legislative action. By equating Kochian fundamental legal principles with Lockean fundamental rights, and then claiming that both are derived from natural law, Sherry jumps from general theoretical commitments to specific systemic analysis, while ignoring the practical and theoretical differences between natural law and common law conceptions of fundamental rights. In alighting natural law and common law, and in relying on Bonham as putative support for a natural law conception of fundamental legal principles, Sherry does more than misread some case law. She threatens to undermine the proper doctrinal basis of extra-constitutional judicial review in the United States. In her failure to differentiate common law from natural law, Sherry has committed the same error as Berger, and it has led them both to misconceive the authentic significance of the common law as legal authority for judicial evaluation of legislative action. D. The source-based judicial obligation to develop the law. In the previous chapter, and in this one, I set out to establish the existence of Anglo-American legal sources that support the common law judicial authority to refuse to enforce unjust laws, even where those laws do not necessarily violate a written constitution. That is the proposition for which the cases I have discussed in these chapters stand. And these decisions Bonham, Amachand, Ham, Bowman, Lindsay, Jones, Calder, Kisham, McIlvaine, and Fletcher should be appreciated for what they are: a discrete, coherent, and cohesive line of reported case law articulating a common law principle and a body of legal thought that reflect the distinctive authority and responsibility of common law judges to develop the law by eliminating instances of injustice from the law, a principle and a conception that have endured throughout Anglo-American common law history. This is the legal basis, derived from legal sources, for judges to refuse to enforce unjust laws. As it turns out, this is what Koch had in mind all along. In this stand for the right to give the common law priority in general principles, Parliament must not go beyond the general principles of the common law or beyond its general reasonableness. This would place statute law in a subordinate place to the common law if pressed to its logical conclusion, and give at least to the common law courts a superior position as the interpreter of statute law. It would in many cases result in the will of the framers of statutes being set aside, or at least modified by the judges of the common law courts. It would, in short, create a practice of judicial criticism or judicial review of statutes by the common law judges. In Bonham's case, Koch contended there was a legal, not an extra-legal, power in the courts to do this very thing. Koch's emphasis in Bonham on a legal, as opposed to an extra-legal power of the courts to refuse to enforce unjust laws undercuts the moral formal dilemma and its overly narrow presuppositions about judicial obligation and authority in common law systems. The judge's obligation to develop the law is not, as the moral formal dilemma would have us believe, limited to a choice between legal and moral obligations. Common law judges have a legal obligation, grounded in case law, to refuse to enforce unjust laws. This is not to suggest that this is not also a moral obligation. I am simply arguing that the judge's legal obligations extend into the sphere that the moral formal dilemma designates as moral, and thereby extralegal. My point is that a judge's legal obligations in these cases are triggered by and track her moral reactions and obligations. The moral formal dilemma erects a false dichotomy between the judge's moral and legal obligations. In so doing, the moral formal dilemma assumes or accepts that a judge's moral obligation may be to corrupt the integrity of the judicial process. Morality requires or prohibits some solutions, in which case the law, interpreted conventionally, might get it wrong. In that case, the judge's legal duty is to uphold the conventional understanding of the law, whether or not the legal system is generally just. The loyal and dutiful judge in a wicked legal system is fully complicit in its wickedness and deserves to be criticized, perhaps harshly. That judge's moral duty may be to resign or to engage in disobedience from the bench, throwing monkey wrenches into the works at every opportunity. To my mind, this is a disturbing, distorted view of a judge's genuine legal obligations, evidencing the powerful hold maintained by the moral formal dilemma on the conventional Anglo-American understanding of the alleged rift between a judge's moral and legal duties. This stunted view of judicial responsibility conflicts directly with the common law vision, which requires judges to exercise their legal powers in accordance with their legal obligations. This was the vision of judicial authority that was carried across the Atlantic, where it finally found fertile soil. A brief return to the period of its planting will help me make this point. St. George Tucker, a preeminent early American judge and jurist, wrote the following commentary regarding the case of Josiah Phillips, sometimes considered one of the earliest American cases in which the doctrine of judicial review was discussed. In May 1778, an act passed in Virginia to attaint one Josiah Phillips unless he should render himself to justice within a limited time. He was taken after the time had expired and was brought before the general court to receive sentence of execution pursuant to the directions of the act. But the court refused to pass the sentence, and he was put upon trial according to the ordinary course of law. This is a decisive proof of the importance of the separation of the powers of government and of the independence of the judiciary. A dependent judiciary might have executed the law, whilst they execrated the principles upon which it was founded. Very early, as Judge Tucker's remarks show, American lawyers understood the importance of an independent judiciary and the relevance that the judicial authority to refuse to enforce an unjust act of the legislature or the executive held for the separation of governmental powers. Moreover, as Tucker recognized, an independent judiciary must exercise independent judgment, because there are certain circumstances in which a judge ought not simultaneously to execute and to execrate a law. If a legislative act is sufficiently deplorable, the judge may legitimately, within the bounds of his legal authority, refuse to enforce it. That is the motivating concern of common law review, as revealed through careful consideration of the cases in which this principle was incorporated into Anglo-American law and legal tradition. Some early American judges realized the importance of an independent, but legally restrained judiciary and its central place in maintaining the rule of law in accordance with the Anglo-American tradition of common law constitutionalism. Early American judges were not the only important legal thinkers of the time who stressed the importance of an independent judiciary whose obligation to protect legal rights against abuses of public power, sometimes by refusing to enforce unjust laws, was neither created nor circumscribed by a written constitution. Certain framers of the Constitution indicated that judicial influence and authority should not be limited by the document they drafted. For example, in a less frequently quoted passage from Federalist No. 78, Hamilton wrote, "It is not with a view to infractions of the Constitution only that the independence of the judges may be an essential safeguard against the effects of occasional ill humors in the society. These sometimes extend no farther than to the injury of private rights of particular classes of citizens by unjust and partial laws." Here also the firmness of the judicial magistracy is of vast importance in mitigating the severity and confining the operation of such laws. It not only serves to moderate the immediate mischiefs of those which may have been passed, but it operates as a check upon the legislative body in passing them. I have here attempted to demonstrate the existence of a source-based legal obligation for judges to develop the law by repudiating unjust legislative or executive action. So far, I have tried to show that judges may refuse to enforce unjust laws. But the judicial obligation in these cases is stronger. Common law review does not just permit judges to develop the law in this fashion. It requires them to do so. The parallel here between common law review and constitutional review is again useful. The rule is that a law repugnant to the Constitution is void, and that it is not only the right, but the duty of a court so to declare when the violation unequivocally appears. Just as constitutional review does not just permit, but requires judges to invalidate statutes that violate the Constitution, common law review does not just authorize, but obligates judges to refuse to enforce certain statutes that contravene common law principles. This robust conception of judicial obligation is entirely consistent with a tradition based in English common law thought that animated Coke's beliefs and informed his decision in Bonham. Bonham is widely accepted as the Anglo-American legal basis for the doctrine of constitutional review. But only by extension was Bonham the theoretical justification for constitutional review. After all, Coke was not espousing a doctrine of constitutional review in Bonham. He could not. There was no written constitution to which he could appeal. So while Bonham is the indirect progenitor of constitutional review, it is the direct lineal authority for common law review. It was Coke's version of the supremacy of the common law principles as exemplification of rules of reason and of justice that served as precedent when American justices were confronted with the demand that limits must be placed on legislative powers in order to safeguard individual rights and privileges. Traced back through its legal ancestry, common law review seeks a fully formed conception of a common law judge's legal obligations and of the place of an independent judiciary in a system of plural government. This is the authentic common law tradition we have inherited from Coke, Mansfield, Chase, and Marshall. We should take care not to forget the long history, in the common law tradition, of an independent judiciary applying common law principles to ensure that the government remains within and accountable to the law. Constitutionalism does not require a constitution.